Apologies for, well, double apologies. Apologies for starting late and apologies for having an interruption.
I was enjoying it all in the back row.
Well, it's kind of you to have been here to observe first panel as well. We will, if we know who you are, I think everyone knows who you are. So if you're content with that, we will move straight into
yes. And I was here. I was here when you all introduced yourselves. So, yeah.
Yes, unless there's anything you want to say in the introduction, but if not, we'll go into questions. Thank you very much. We're starting with Sarah Russell.
Thank you. So there's obviously been discussion in the room about the impact of recent reforms to the family courts and the impact of delays in both public and private law cases. What are your reflections on the various initiatives and reforms implemented to address delay in the family courts?
Well, that's a big question. We've come a long way. The delays were at a high level for public law, going back to, you all quite correctly quoted that we've never got to the 26 weeks, but we got very close to it it came in 2014, in about 2015-16 we got close to it, which was astonishing because I was the one of the 5 people on the Norgrove committee. I was the only lawyer, and we looked at the delay there, and it was 61 weeks, the average, when Norgrove met, and we put 26 weeks in our recommendation, thinking that by a statutory instrument over a course of 5 or 6 years, it might be ratcheted down to 50, 40, 26, but government quite understandably said, oh no, we'll have that, and they took the 26 weeks and implemented it, and we invented a structure, the public law outline, to cut the number of hearings and to get to that. And we got to 28, 27 weeks national average in about 2015. But then suddenly the volume of new applications rose by about 25% in 2017, 18. And my predecessor, Sir James Mumby, called it the care crisis. And he said, we don't know why that's happened. We don't know what to do about it, because we were running at capacity to do what we were doing. I won't go into why, but it was basically austerity. The resources for social workers to do anything else but come to court had been reduced. And that's where we were. And then COVID hit us, and the backlog went up to about 13,000 cases, and the time taken in cases went up to about 46, 47 weeks. And so since 2022 or so, we've been trying to pull the thing back. And we're direction of travel is very much in the right direction. Down to nationally, I think it's 34 weeks now. Many areas are at or near 26 weeks. It's London and the South East, which is at a much higher figure. So what are the causes? What are we doing about it? I think after COVID, I understood from everywhere I went that people had just lost any connection with 26 weeks. They were just doing the cases, and delay had become normalized. And so I felt we needed a wake-up moment. And so in January 2023, I relaunched the PLO and said, look, everybody, we know this works. It's untenable because the delay was getting worse and worse. And the longer you leave a family case about children, more stuff happens. And the case comes back to court and they say, oh, no, well, since the last hearing, that's happened, you've got to assess this. So I relaunched the PLO, and I think everybody got that message, and that's what's been happening. And I relaunched the relaunch last autumn just to make sure the message has gone back. So that's where we are, and we have got very few levers, but what we're doing is trying to make every hearing count and keep the hearings short. And similarly with private law, the volume went up after legal aid was largely removed, because litigants in person weren't meeting solicitors who were saying, come on, you don't want to go to court about that. And I think the perception in the public may have been that the lawyers were generating the work, but I think the statistics show it was the other way around. And again, in COVID, obviously, there were a lot of private law cases were generated by the circumstances of COVID, and that's harder to bring back down. Partly because we can't engage with the people who come to court for a private law application until they've issued their application. And we can talk to local authorities in public law cases, try and change their behaviour. and we're reliant on measures from government in the end to provide support, information, education, mediation for separating parents so that they don't think they need to come to court to get the volume down. And that's work in progress.
There are so many things that could be unpacked there. And I do worry sometimes that we talk about this in quite sort of dry terms, but actually we're talking about highly vulnerable children, particularly in relation to the ongoing delays in London and the South East. What's the cause of that?
There's no one cause. We are under-resourced in the court in London and the South East, particularly with judges at the district judge level in the South East donut around London. That's not so much a problem in London. We're partly in London the number of courtrooms, and so there's a limited resource, and that's obviously very vulnerable. If the volume goes up, we've got the same number of people, the same number of Cafcass officers and social workers to deal with it. But I think also, and I'm spoken publicly about this, I think in London a culture had developed of allowing cases to drift, and in particular also moving away from having the same judge at every hearing, which is hard to do, but it pays dividends if you do have continuity of the judge. And so in November last year, we launched a bespoke strategy for London, imaginatively called the London Strategy. And the aim of that was to deliver the rather unpalatable message to the professionals there, saying, look, everybody, what you're doing is out of kilter with the way things are done elsewhere. And it is. And that's, people have listened to that. And the judges, I think, particularly welcomed the fact that someone had said that. And the focus is now to drive things down, and the figures for London are beginning to move in the right direction. But it's regrettable that it was only during the course of last year that penny dropped, that London was partly a behavioural thing, a cultural thing, rather than simply the volume of work. But that's where we are with that.
What's the vacancy rate for judges doing this sort of work in London and generally?
London, I don't think it's such a problem in London. In the South East, I'm happy to give you the actual data, but I think we're about 20% down on the number of district judges. And whenever there's a competition, because that's what it's called, to recruit more district judges, there's also a competition to recruit more circuit judges, and a proportion of the new circuit judges are district judges. And so you're putting people into one bucket while the bucket's being emptied at the same time. So it's playing catch up. So we rely a lot on fee paid judges, and they of course can decide whether or not to take up the invitation to sit.
You talked about the relaunch of the public law outline, including the case management outline to encourage parties to meet the 26-week deadline. And how has that been working in practice outside of London? Or is it just less necessary there?
I think it's working. As I say, the figures are showing it's all coming down. At the moment, in the last 3 months, we've observed that the volume of fresh applications, this is for care orders, has gone up about 10-15% across the country. And again, we don't know why that is. Speaking to those in local authorities, and this is anecdotal, I think they would report that the volume of referrals coming in the front door from schools, from police, from members of the community has gone up at the moment, and we get a proportion of those through on into care proceedings. But I don't know. But apart from that, it's working well, and there's a tight group of key judges at the 42 centres around the country, including obviously London and the South East, that they're designated family judges. And I'm in touch very regularly with them. They're in touch with each other. We share all these messages together. If someone has developed particularly good practice in an area, Coventry is a recent example, a person from Coventry shares all that. So I think we've all become more connected, and we're looking to work together and learn from each other. And I think that's partly one of the positives of COVID. I think people do meet up more regularly now in our non-system, and that's very, very helpful.
And are the checklists the right method to improve timeliness, do you think?
These were the checklists that were piloted by the DFE. I think that they've stopped piloting. I think the view was, therefore, they didn't particularly add value. And my view was that they were fairly straightforward checklists being given to professionals who really ought to be thinking these things through anyway. So I wasn't surprised that it didn't really change behaviour very significantly. So I think we resort to just good practice more generally without adding another piece of paper to be put through the system.
Would it be possible, Sir Andrew, just to go back to your point about the lack of district judges? Because I was quite struck by what you said about there being 20% down on district judges in the southeast. And you refer to the simultaneous recruitment of circuit judges and district judges, but I just wondered if there was any other aspect or any other relevant kind of dynamic that's going on that's relevant to that lack of ability to attract full-time district judges.
I think it's an interesting question, and it's one which the Lady Chief Justice is probably better able to answer. And it's something that we at the level of the Chief Justice and I as a head of division, we've been looking at over the years. It's a complicated set of consequences, partly to do with alterations to the judicial pension scheme, partly to do with payment of expenses, partly to do with the fact that quite a few fee-paid judges now have a portfolio of fee-paid appointments. And so they won't necessarily just be a deputy district judge. They may be at the mental health tribunal. They may be part of the wider tribunal process. And so they may have nearly a full-time occupation being a part-time judge. And so the question, what is it that might attract them to become a full-time judge is one that needs to be asked. It's a hard job. Being the district judge is at the pinch point of the whole system, and so I'm very grateful to those who want to be district judges. But I think it's not necessarily the career choice that everyone would make, whereas it might well have been 20 years ago.
Yeah.
I just want to pick up on that point again, if I may, Sir Andrew. Does the fact that there are insufficient district judges available to do these cases influence how the gatekeeping mechanism is done across different regions and how cases are allocated, whether that's to magistrates, whether it's to district judges, whether it's to circuit judges, because of that pinch point that you've described?
I think that when I say there aren't, the absence of salaried judges in any particular place is made up by having the fee-paid judges come in. So inevitably, they're different. Each week, it's a different person who's occupying that chair. I don't think it alters the gatekeeping, because that tends to be done by just one or two individuals who always do it in particular court centres, and the legal advisors who are salaried also do it. It may alter the allocation. It goes back to what I said earlier about putting the case into the list of judge blogs, and so it's always then with judge blogs, because there may not be a full-time judge there, and so it alters the case's life after the gatekeeping, but not necessarily the choices that are made at gatekeeping, if that makes sense.
It does. I just wondered whether it would influence, because of what your resources are further down the line,
I think
where you allocate those cases.
Yes, so it's not. I don't know that because I'm sitting at my end of the tube. I don't get to see that, but it wouldn't surprise me.
And have there been any studies that have looked at that, about decision making of those individuals who are doing that?
I haven't seen any. No.
I'll talk about Anna in a moment, but Pam, did you have a short point?
Well, we're talking about the relaunch of the public law outline. I remember the first one. Is there a space in any further iteration of the public law outline to include a requirement for the offer of post-proceedings engagement to be made to parents, just the offer of post-proceedings engagement, or is that not the place to do it?
They're different. I think I think there weren't any answers that you were given by the three previous witnesses that I disagreed with. So I'm entirely was pleased by the questions you asked there. But it's the public law outline is the in-house case management system for the cases before they finish. So they're not to do with that. Something that wasn't mentioned, and you suspect will know it, is there are initiatives like Pause, which is funded by some local authorities, which engage with a mother, as it will be after the end of the proceedings, and will say to her, look, if you pause having more children, if you agree to go on to some slow release contraception, we will work with you to address the problems that you might have, drug, alcohol, whatever they may be, relationship, domestic abuse. And that the success rate of pause is really very high. The women who've been able to turn their lives around during the pause go on to have children subsequently, may even be reunited with the children that have gone into to care. And so I'm a great supporter of that sort of initiative. FDAC is the same idea, live during the currency of the court case, but it needs resources from local authorities.
Okay.
Thank you, Sir Andrew. You mentioned the designated family judge approach. I understood it to be a pilot, or were you suggesting that is now sort of usual business?
Now, I may have confused. Every court has a designated family judge who's the judge in charge of the family business in that patch, and that's always been the case. So maybe what I said was that they're even more in touch with each other now, and they share good practice.
Yeah, so as I understand it, there's been a pilot where these designated family judges are operating with delivery partners to do this deep dive analysis into the delays.
Trailblazer.
Yes.
I think there's so many initiatives.
Yep.
I think that's the one.
Pathfinders, Trailblazers.
Yeah.
Yes, I'm on Trailblazers.
Yeah.
And obviously you'll have heard from our previous witnesses, they talked about a lot of different reasons for delay. You yourself have touched on some of them. So could you just reflect on what's been successful about that pilot, both in terms of identifying delays but addressing them? I'll leave it there.
I think it's if you're interested, it's worth looking at the Trailblazer report. It was, I think, 5 areas they were particularly involved with, and they would then also engage with about another 10 or 15. There were different problems in each of the different areas, or they were the same problems, but they were more acute in some areas. So there's no one size fits all. I'm sure that the courts that they visited benefited from having the problems unpicked and identified and then addressed separately. Because if you're running any organization, if you're in the middle of just doing the day job, you don't have the headspace to do that. And I think it was very useful that happened. In the end, the messages from it were pretty simple, which is useful. And it was the sort of thing: keep the cases short, make sure things are coming on. The delay is the enemy of any litigation, but for children it's appalling because it's another period of time where they're in limbo and these issues aren't resolved. And as I've said, often the problems become more acute, and so addressing the causes of delay and shining a light on those were good. So I think that what would be useful is to go back to the areas now, a year later, to see whether lessons were sustained and pennies that remained dropped. But it was a good thing to do. And again, the Trailblazers have shared that report with all the other DFJs, and they've spoken at the conference I have with the DFJs. So bit by bit, there's learnings coming through.
We heard from the witnesses things like needing to get repeat expert input, or that some of the cases were being delayed. You've mentioned legal aid, more people representing themselves effectively. So I'm guessing not all of those are within the control of a designated family judge. So what are the other sticking points that need to be addressed out with, that the Trailblazers in a sense identified but couldn't deal with?
I'd have to go back to the Trailblazer
Right.
report to see
Okay.
that's a question about what they didn't deal with and where we are now.
But do you have any insights yourself into the whole
they're,
issues?
they're old problems. In public law cases, the local authority issue their proceedings because they've got a view of the case. They may or may not have undertaken thorough assessments of why they've got that view, and the case starts. And certainly prior to 2 or 3 years ago, it was the norm that the court would say, right, this case has started, we will need a psychologist, we will need a hair strand test, we will need whatever else in terms of new experts coming in for the first time. And there's because the volume of cases is such, the number of experts is limited, and they can dictate the timetable to a degree, so immediately went into delay. So 3 or 4 years ago, a group called the President's Public Law Working Group, another imaginative title, identified that it would be a game changer if all local authorities, in cases which weren't urgent, so these are children that are on their books that they're worried about, but they don't have to come to court today, conducted thorough assessments, A, so that they understood more clearly why they were worried and whether they were still worried, B, to look at other options other than coming to court, so that they only came to court when they really needed to, and we did see a drop in the number of applications after this, but also in terms of the assessments that the court application would be match fit for the court process. And the other part of that balance was that I was very plain with the judges that they shouldn't then automatically order fresh experts or suck air through their judicial teeth and say, why didn't you come 6 weeks ago or 2 months ago? Because they could, but they've spent that time in reconnaissance. And so that's been a real difference, both in terms of lowering the volume and shortening the hearings, because unless there's a really good reason, the parents and Cafcass can't expect to have a fresh expert brought in.
And does continuity of judge play any role in this?
It does, and it's the golden model. It's more easily achieved in the smaller court centres, where often it is only 1 or 2 judges. But in the bigger centres, it's very difficult to achieve. But that's if possible.
Do we have data on how many cases actually do get continuity?
I'm sure we could,
right.
But I don't see that. It doesn't come
Thank
across
you.
me.
Okay.
No.
Just
In terms of that, in what percentage do you think of judges working on these public law and private law children cases are currently part-time?
I think the public law cases are fewer. I think the public law cases tend to be done by the full-time judges. So I'd have thought probably 20-25%. This is a finger in the wind figure, but about 25% part-time. But most will be done by the full-time judges, partly because the cases are allocated on the system, the digital system that we do have for that, to a particular judge. And also the model works. The case comes in and there's a hearing in the first 2 weeks to set it up. And then the only other hearing that should take place is an issue resolution hearing late on in the 26 weeks, where the judge eyeballs everyone and says, well, do we really need to decide this issue, or what's the position on this? Why and then the final hearing should be relatively shortly after that. And all the experiences, if you've got the same judge who says, right, well, if we're having a hearing, we'll have it in 6 weeks' time, and I'm going to be the judge, that concentrates minds much more clearly at the issue resolution stage.
You think private law?
So it's private law that where I'm afraid we see more of the negative lack of judicial continuity. And that's also partly human. If you're litigants in person and you're getting a different judge every time, then you try and tell your story again, and that's human nature, isn't it?
Thank you, Chair. So, Andrew, I want to talk about early intervention, just picking up from where we left off on private family law. You've said that change in that area is your principal priority. So I just wanted to ask, what do you think are the specific changes that are needed? I mean, maybe we've already dealt with it, but specifically in relation to that, what are the changes that are needed and how are we getting on in implementing those changes?
Well, this is well-trodden ground, and if you're interested in this, it's all set out in a report called What About Me, which was published by a group under the President's private law working group called the Family Solutions Group in, I think, 2022. What About Me? And in that, it sets out all of the interventions that ought to be in place to support couples when they split up and they need to have some help resolving issues about their children. And I was very pleased that when Dominic Raab was Lord Chancellor, he accepted that this was well-trodden ground and that the Ministry of Justice had never actually engaged with it. It had always been something. And he consulted on a whole range of about 10 or 12 elements of this catalogue of interventions. And government, the previous government, published its proposals or response to that in February 2024. And it's called Supporting Earlier Resolution of Private Family Law Arrangements. And there you will see a list of things: improved information, a neutral, authoritative, detailed web presence on gov.uk, support and guidance, partly going into family hubs, which MPs will know are in a lot of localities, provision of the SPIPs, the separating parent information programs that were mentioned earlier. Those aren't available at the moment unless you come to court. And the proposal is that those will be funded. They're like a speed awareness course for parents. And I don't think I'm belittling it. It's exactly that. Mediation vouchers, and also they were suggesting early legal advice, which those of us who are a little older than some of the others will call green form legal advice. So it would be, in the modern world, a parent having 2 hours paid for legal advice online with a solicitor, probably somewhere else in the country. So those were the sorts of things, but they need money. The new government, the previous Lord Chancellor, was in favour of what had been happening, and some of them are progressing. In particular, the web presence is being funded because it's likely to be of great benefit, and it may well be used in other areas of the law. The mediation voucher scheme carries on and is interested in doing more. But that's the list. That's what's needed. And the feel that those of us in the court have is that there are a lot of cases that need to come. The domestic abuse cases need to come, but a lot of people come because it's the first port of call. Mm. And what was striking to me was an account given. This Family Solutions Group went to for a pilot to Birmingham to spend 2 months, I think every Monday, providing this sort of intervention and advice in a local family hub, or I think 2 family hubs in Birmingham. And they were astonished that the professionals working in the hub had no awareness of most of the things I've mentioned, no awareness of mediation or the voucher scheme or a SPIP or MIAM. And so I think there's a feel out there that if you've got a problem with your ex, you go to court. Mm. And that's a major impediment to us being able to move forward, because going to court doesn't help. There's a book called Almost Anything But the Family Court, and I, as head of the family court, wrote the foreword to that.
Just picking up on the mediation information and assessment meetings, which I think were one of the outputs of that review in April 2024, that was supposed to radically tighten up, or there have been radical tightening up to the process. What effect would you say that the tightening up has had, if any?
Well, I'm very disappointed in that because it needed tightening up. This is the MIAM as a requirement before you, if you issue an application to come to the court, unless you're exempt, domestic abuse, for example, you've got to go and meet a mediator to talk about mediation for an hour. And the statistics show that if you do, a large proportion go on to attempt mediation and a fair proportion end up resolving themselves. But it had fallen into really disuse. And so we tightened up the exceptions and we made it a mandatory requirement that the judge had to send them back if they weren't exempt. But the data, such as it is, shows that I think there's the increase. It's been in now for 15, 16 months, hasn't it? The increase is about 1% in the number of MIAMs being taken up. So I need to revisit.
And we collect the right data on this. I mean, do we know what proportion of parents who go to MIAM actually start mediation? Or
I should have written that down to tell you. I think it's about 60%, but we can give you the precise figure. But it's a good figure. It's impressive, and I think many in the public don't quite know what mediation is. I don't want to get back together, and that's not what it's about. And I think that's not making fun of it. I think that is a perception, and I think when they sit down with a mediator and understand what the process is and what a mediator looks like and the sort of things they say, then I think it's quite attractive. It should be to them.
And what reforms are most important to get us to the point where parents do see court as a sort of real last resort rather than the first resort?
I think it's banging that message home. It's the catalogue of things that the government policy. If this MIAM tightening up is part of a much wider jigsaw. It's the only bit we've done, and it sits alone at the moment. It's funded, and the take-up on the mediation voucher scheme is impressive, and it's good in these tight financial circumstances that the Ministry of Justice continues to fund the voucher scheme. But the whole apron around the court needs to be populated with these other resources to just allow people to understand what people do when they split up, what normal looks like, and just feel reassured that they're doing something that's right for their child. These are frightening, bewildering times when you split up. And so that's a big change. But until we start trying to do it, it won't happen.
And lastly, for me, just on the early intervention scheme, but in relation to public law, I mean, we've been talking about the public law outline, but I mean, what would the family group decision-making meeting, which is in this Children, Schools and Wellbeing Bill, add to that PLO process, pre-proceedings process, do you think?
Well, it's a step that's undertaken by quite a few local authorities now. This is, and the aim of the bill is, I think, to make it uniform. There's 152 local authorities, to make it uniform. I think, I mean, it's difficult because I'm a judge and I shouldn't be commenting on the content of a bill. I have seen the family rights group's response to the bill, which is that, yes, this is a good start, but there's not much detail in it. And it talks about a meeting, whereas they see the family group conference as being a process that may take time to set up and then move forward. I think a lot will turn on not so much the wording of the clause that goes into the Act if it's passed, but in the guidance and regulations that underpin it.
As a concept.
As a concept, is absolutely what ought to be happening, and I think that's what all three of the other witnesses. It's very welcome, because often in a family, even if something really awful has happened, in the care of the parents, there will be safe members of the family who can come forward, and they need permission to come forward and encouragement to come forward at an early stage. And that can change the course for the child from going through care and then on into adoption to having a life where they're living in their family with a knowledge of their parents, even though they can't, it's thought, safely live with them.
Thank you, Sir Andrew.
Thank you. Oh, we're into that.
Thank you, Sir Andrew. I'm going to ask you about the Pathfinder courts,
Yes.
and you've said previously that you think that they are the future for private law cases. So what feedback have you had from parents, children, and victims of domestic abuse about their experience of Pathfinder courts, and why do you think they are the future, and do you think that that is what we are heading towards for the future?
The feedback at the moment is limited. We've only been doing the courts for 2 or 3 years in 2 centres, and then much more recently in other places. In Wales, where they have them in all family courts now, the feedback is that the majority of those who've been contacted were happy with the outcome, and they felt they'd been listened to, and the children were pleased that their voices had been heard at the beginning of the process, which is obviously a key element of Pathfinder. And then in England, we've got I won't read them out now, but quotes from children. But the phrases I've seen is that the parents and domestic abuse survivors feel better informed, they feel better protected, and they feel they've been listened to. And a key element of Pathfinder, I'm talking as if you all know what Pathfinder is, but there are 2 key elements to it. Perhaps if I spend a minute just saying what it is. The current model, a couple come to court, one of them may be represented, often the other one isn't, and the court doesn't know much about it. So it says, what's this case about, Mr. and Mrs. So the judge is sitting back reacting to the adults, and it's led by the litigants. And it's only if it carries on being contested 8 or 9 months or more down the track that a report from Cafcass comes in, and someone's spoken to the child, to the school, to the doctor, whatever, and the court has got some independent knowledge about what's going on. But by then, things have become entrenched. Cafcass does Pathfinder does 2 separate things. Pathfinder, firstly, before the very first hearing, Cafcass do all that. So in the first hearing, instead of reacting to the couple, the court's got the full clip. And in my mind's eye, the judge is leaning forward saying, well, look, you two, look what's written down here in this report called a child impact report. Is this a description of what's going on? Yeah, well, it is. Well, look at the impact on your child of where you two are at the moment. What are we going to do about this? And immediately it's an informed process, and the judge has got a pretty clear view about what's going to be the better outcome for the child. Secondly, and importantly, the MOJ put money into the Pathfinder areas to fund domestic abuse professionals, to make sure that there are those resources, and those individuals, professionals, come to court much more often with Pathfinder to support those who are the victims of domestic abuse. And as was said earlier, there's a domestic abuse appraisal as part of this information that judges got. And so domestic abuse is far more in focus with professional input at that first hearing in a way that just is not the case now.
And are these cases getting resolved, or are they coming back?
So they tend to, at that first hearing, some of the cases, it's so obvious what the outcome will be that at the gatekeeping stage, when the court has a look at the report, it will make the order and say you can come back if you don't agree with this, but that's the order. Other cases resolve at the first hearing. If there is a second hearing, it tends to happen 2 or 3 weeks later, and the hearing is not about fact-finding, it's about what we're going to do. And so the only witness might be the Cafcass officer or the parents talking briefly about what they say. And so it'll be a short hearing, and the case is resolved at that stage. And there's a lower level of people coming back to court to dispute matters.
So back in June, the Public Accounts Committee heard that it was a bit of a challenge to roll out Pathfinder courts in London because of high caseloads.
Yeah.
Is that still the position, or is the situation getting better?
In order to do what I've just described, we'll have a hearing in 4 weeks' time. You've got to have the backlog pretty well cleared. And what we've done in the bigger centres such as Birmingham and Leeds and Cardiff, where Pathfinder was rolled out, 9 months before it started, we had a concerted effort to clear the backlog. And we've learnt a lot by that. And the courts that it's going to now, which are Staffordshire, the Black Country, and Worcestershire, Hereford and Worcester, and then Hampshire, because they're close to current Pathfinder courts, have got low backlog. London have started to get their backlog is enormous, get their backlog down. MOJ's put extra money in to have extra courts sitting. And again, the figures show the backlog is coming down. And we've learned from Birmingham and Cardiff and Leeds that if you have a concerted push and get the cases in, often the people are very relieved to be brought back into court. Quite often life has moved on and they've rearranged themselves anyway. So it's less of a challenge, actually, when you start attacking the backlog than people have thought it might be. So what the plan is depend upon the MOJ authorising Pathfinder to go anywhere else apart from the 10 courts it's going to be at by the end of this financial year, will be to address the backlog in London and the South East particularly, but everywhere else for Pathfinder to start.
Do you think it's something that we are likely?
It's doable. It's doable. But it's because it is where it is. It's a big, it's a challenge. But already it's moving in the right direction.
Thank you,
if my eyesight was good, I could give you the figures for London, but I'm happy to send them in.
Can I just move on to the Family Drug and Alcohol Court? Because I think previously you said to the committee that it was that court is a bit of a postcode lottery.
Yeah.
And what is the reason for that, and what are the reasons for that lack of provision?
It again, members of the committee will probably know what the court does, but these are public law proceedings, and if the presenting issue is, it will often be a mother, but may well be a father with drugs and or alcohol, and there's often been previous children removed, they'll say, look, are you prepared to be assessed, and if it's appropriate, engage with this group of professionals that are available to address your addiction problem while we get the case carrying on, because it'll take 26 weeks. Yes, and they do, and then they come back and report to the judge in a bit of the way that happens in the criminal court in a different context with drugs, every 2 weeks, just to have a review. And it has a high success rate of supporting these individuals to kick and to become dry, become clean. So that's all good. The problem is who pays for this group of psychiatrists, psychologists, specialist addiction social workers, because they're not part of the court system. Answer, probably the local authority. That's the normal source. Police commissioners pay in some areas. Some charities pay in some areas, but it's haphazard, the funding, and it's not cheap. All the research of FDAC shows that for every pound spent, it reaps 2 or 3 pounds benefit, and you can look at the research. And so, but it's getting the money up front in the course of the financial year. And so what happens is that local authorities who have geared themselves up to do this can run the FDAC, and some courts have been running for years. But quite often, it's happened in Newcastle in the last 9 months, they say, I'm sorry, we can't fund it anymore. And they go. And it was almost the same week that we opened one in Liverpool. And we've lost most of the local authorities from the Black Country at the moment. And so it is a postcode lottery, because it depends upon the local authority in each postcode to be able to fund it. And so I've got to tread carefully, Chair, because I'm a judge. But it does occur to me that the social benefit of using the court as a moment in someone's life for intervention, with the judge as a parental figure, does achieve massive change for these individuals. Their lives turn around. That it is something that across government might be looked at. It's not actually an MOJ problem. The MOJ do their bit by providing the courtroom and the judge to be the facility, but it's the Home Office must have interest in this, Department of Health, Department of Education. But I'm a judge. I couldn't possibly even have just said what I have just said. And the reason that I am passionate about this is that although it says on the tin drugs and alcohol, I understand that every case, if it's not every case, it's nearly every case, an underlying feature is domestic abuse. These individuals are serially victims of horrid, sustained domestic abuse, and turning to drugs and alcohol is a coping mechanism. And the professionals working in FDAC say we often have to address the domestic abuse first before we can allow the individual to have confidence to move on. Well, if that's right, that it's a domestic abuse, if it's a facility that will address domestic abuse, then all the more reason for it to be taken seriously in the campaign that government rightly has on focusing on violence against women and girls. So I hope I haven't overstepped the mark. I may have to retire.
Well, I perhaps shouldn't ask the next question then. But I mean, I think you obviously are of the view that we should have a family drug and alcohol.
Yes, I've been on record for a long time saying that. Yeah.
But it's just getting that funding sorted. So somebody else needs to provide that.
It's always money, isn't it? And so it's and that's I have the luxury of not having the decisions to make about money. I can say I've not met anybody who is against FDAGs. It's just a matter of financial priorities, isn't it?
Thank you. You alluded to retirement, and we made us aware that this could be the last time you appear in front of the committee. And what we were going to do in the last part of the session was to reflect on when you were here before and ask you about some of the changes that have taken place. I'm conscious the vote's going to come at exactly the wrong time.
You're going to have a vote now, is that?
5 minutes.
Yeah.
So I can tell you what we're going to ask. I think we would then have to disappear for 10, 15 minutes. If you're not able to stay for that, you could always reply to us in writing. But if you are able to, then...
I'm able to stay. It's a question of whether you want to come back to hear the answer.
we were going to very, very briefly cover the topics of domestic abuse, AI transparency and liberty order. So nothing too complicated.
Right. Okay.
If we're happy, I don't know if you want to do on any of that.
I think the most important thing really is that when you gave evidence before this committee in April 2024, you suggested that to avoid the problem of special measures not being in place when victims of domestic abuse attend court, that they could be in place as default. Do you know are steps being taken to implement this?
I think a lot of courts now, the experience is that special measures are used so often that the kit is in the courtroom and it's quite easy to take out. I don't know whether, I say it certainly isn't the case that it's the default in every court that it's there, but when I visit courts, it's and those of you, the rest of you, visit courts, the screens are always there. I mean, it's all pretty rudimentary, but it's I think it's part of ordinary business now, and I think that's an element that we've moved on. But I think we haven't got the resources that I could dictate, if I could dictate that it should be all the time in every court.
In terms of final sort of reflections, if you don't mind me asking, I wondered two things. One is, I'm sure you're irreplaceable, but do you know how matters are going in terms of finding a replacement? And secondly, do you have any reflections you'd like to share with us, on your term as president of the family division, or other issues that you'd like to talk to us about?
Just see the chair's eye on the clock, but
you haven't heard a bell. You're good.
There will need to be a Judicial Appointments Commission competition to find my successor, and that will start. And I've given 6 months' notice on the understanding that the successor will be identified before the end of that period. So I don't know any more about that. It's not a matter for me. It's a matter for others. Looking back, it's just been a time of enormous change we discussed quite a bit of it, but goes back to a question you asked. In the course of that time, somehow your nosebleed. In the course of that time, we have rolled out the digital programs for almost the entirety of family justice. So that's private law divorce, which is working very well, the financial remedy side of family cases, and the remaining bit nearly ready to go is the private law, but it's not quite ready to go yet. Well, that's been, if you were a judge in the courts at that time or in the court offices that time, a very challenging process. That none of these, despite the best endeavours of the people behind them, none of these processes work straight out of the box. And it's taken much, I think, when I became president 7 years ago, we thought we'd finish that process in 3 years, and we still haven't. And so that's been a characteristic of the whole time I've been president, but we've effectively got it done now, and that's a major development. And then what I've talked about has been a prominent part of my time. The one thing I haven't mentioned is transparency, and you will know that we've opened up the court, and it's now part of business as usual that journalists can come in and can report what goes on without naming anybody. But being transparent is much more than simply letting a journalist in. It's a attitude of mind, being open. So I've been prepared to go on the radio, give interviews to journalists in the way that judges probably haven't before, because I think the public have a right to understand what we're doing on their behalf. And I think being transparent will carry on, and we carry on being something that will need to be looked at. I hope all of you visit your local family courts. I hope I've encouraged all the local judges to encourage their individual MPs to come in. I'm sure MPs visit the local schools, local hospitals. Why not the local family court? Journalists to come into the local family court, not to report a story, which of course they can, but just to see what goes on, what makes it tick. And I just don't, we were called the secret family justice system or the secret family court, and I don't think that can be applied to us now. We don't want to be. And I think that change has been a big one in my time.
Thank you. I think I may make this the last question. That you told our predecessor committee that you wanted some clarity looking long term as to what the court of the future would look like and what staff will be in the building. And I noticed that you recently appointed a national lead judge for AI. What does that role involve, and what role do you see for AI in the future of the family court?
Those are two separate things, equally important. What I was talking about on the last occasion is, I think, uppermost in the mind of family judges up and down the country. Once the computer programs are up and running, what will be the staff resource in the building, human beings, to support the judges? And I'm very pleased that work is now being done to look at what the court of the future will be in terms of that support. It's crucial that the judges are free as much as possible to do the judging, rather than becoming quasi-administrators in running the computer systems. AI is fascinating, and all of us were only where we are now in October 2025 in our understanding of it and what it is capable of doing. I've appointed a judge to be in charge of AI, not because I want by next Thursday the family court to be doing everything on AI. What I was conscious of was the fact that this was all developing and we needed to be informed about it and understand what it can do for us and what to be aware of.
We've got a couple of minutes.
A couple to be aware of. I'm keen on transcripts of court hearings and particular judgments being available much more than they are. And it's a burdensome thing, getting a transcript. It's an expensive thing, and judges have to read them and authorize them. I'm sure AI can be very useful in producing far more efficiently a transcript, for example. And AI should be available to, again, more efficiently anonymize a judgment so it can be put out. But we need to be wary. There's already been cases where AI has been used by lawyers to produce documents which have, hopefully inadvertently, produced, I think it's called hallucinations, non-existent decisions. So it's something we need to be fully aware of.
Yes.
But you'll need to ask the next president what it's all about in terms of where it lands.
Thank you very much indeed. We're not going to keep it any longer because we may have more than one vote.
I think we've covered the ground.
I think we've covered everything. If there's any clarification, we will write to you. I'm going to close the session, but can I just wish you well for the rest of your term in office, whatever you do after that. And thank you
very much
for bearing with us.
And I'm sure you won't need to invite me back again. But if there is anything you want in terms of fresh information, then please ask. Thank you
very much. With that, let's conclude this afternoon's business. Order.